affords, but also the personal dignity of the individual that the guardianship is sought over. When people hear the term guardianship, they often think it's someone just taking over the life of someone else entirely, and in reality, it's a much more careful, structured process than that. There's a lot of safeguards in place that I'll go over. Guardianship is a legal arrangement where the court appoints somebody to make decisions for an individual who is incapacitated or does not have or no longer has the ability to make those decisions for themselves. In Kentucky, it's handled by the district court. So here in Madison and Clark County, that is me. And generally speaking, there's two categories to talk about. There's guardianship, which is personal decisions, things like medical care, living arrangements, day-to-day well-being, and then there's conservatorship. Conservatorship is financial, so it's talking about paying bills, managing income, benefits, and really handling property. Often comes down to real estate as well. So those are the two things that the court deals with. Often it's petitioned and the same person will be appointed for both, but that is not always the case. One person can be appointed as a guardian, one person can be appointed as a conservator, and they have to work together. I've had multiple times where an individual, a family member, is appointed as a guardian. However, the state gets appointed as a conservator because of concerns about the individual who's appointed as a guardian financially. Not to say I have seen people who appear to be bad actors seeking control over funds, but that is not typical. That is absolutely atypical. But you will see people who just don't have the best track record financially, have filed multiple bankruptcies, things of that nature. They have something in their background that does not make them suitable to serve as both the guardian and the conservator, but they would still be able to serve as the guardian. I do want to emphasize that guardianship it's supposed to be the last resort. So it is not something that the court takes lightly. There are many things that are supposed to be considered before a guardianship is actually granted. So the law recognizes the fundamental right of an adult to make their own decisions and a fundamental right of them to make their own bad decisions. So just because someone is forgetful or eccentric or just because they're elderly or because their family doesn't agree with their decisions, that does not mean that they're eligible for a guardianship. Individuals can make their own decisions. The legal question is whether the individual has the adequate capacity to manage their own affairs financially and make safe and responsible decisions for themselves. And again, we look at least restrictive alternatives first. And there's also a difference between a full guardianship and a limited guardianship. So it can be narrowly tailored. Someone can petition for full guardianship, but then it appears to the court that they have capacity in many respects, but maybe it's purely a healthcare decision where someone needs to be appointed to make decisions for them. So things can be very narrowly tailored. So it is not all encompassing, it is very specific to the facts of the case. And sometimes families can avoid guardianship altogether through advanced planning, through powers of attorneys, healthcare directives, living wills, trusts, and other legal arrangements before incapacity gets started, before that occurs. But unfortunately, many families don't have these conversations early enough, so the court gets involved when it becomes a crisis. I won't touch on all the difference between a power of attorney and a guardianship because I know that's a topic later today. But one key thing to think about is a power of attorney is a voluntary agreement. You're signing it, you're consenting to it while you have capacity. While you're able to make those decisions, you're giving someone power. A guardianship is you no longer have capacity. So it is being petitioned, it has to go before a court because you cannot voluntarily make those decisions anymore. So how does the process work? A guardianship case begins with a petitioner. So a petitioner files the paperwork to take guardianship over a respondent. That's what the person is called. The respondent is who the guardianship is sought over. And when that starts, I then appoint legal counsel, so a guardian ad litem, to represent the respondent and their wishes, not their wishes, their well-being. So an attorney will be appointed, a guardian for them, and also an interdisciplinary team. So that'll be a team of 3 people, a doctor, a psychologist, and a social worker. This team will then evaluate the respondent. They will meet with the respondent, have appointments, and create reports that are then given to the court. The court, so the Commonwealth, the county attorney's office, they pour over those documents and the guardian ad litem. So we take a look at those and then we have a hearing. We take testimony, typically from the social worker who is in the courtroom, and they adopt the findings of all the reports. So those reports come in, and if all reports agree that there is an incapacity and that they recommend full guardianship, full conservatorship, then that appointment will be made. But then it comes down to who is being appointed. Because as I said before, most of the time it is straightforward. There is somebody in the family that everyone agrees with to take over, such as a spouse or a child. However, that is not always the case. So once there's a finding for guardianship, then it is who is going to be appointed. And that can be a very messy, a very emotional process of taking testimony from family members, having those hearings. And again, I want to emphasize that majority of these cases where there is a fight over who will be appointed, it is not bad versus good. It's usually good people on both sides who just have very different wishes for the respondent. So that is the process. Those reports, they can come in different. I've had multiple cases where the doctor believes there's no incapacity, whereas the psychologist believes there's incapacity. So then it really comes down to weighing up the facts, taking a lot of testimony, and making the decision that's best for the respondent. Once someone is appointed, that's not the end of the process. It's actually just the beginning of the process, because there are reporting requirements. The guardian and conservator must make inventories, and they must file oftentimes quarterly reports showing all the monies that are spent, the arrangements that are made, where is this person at, what is happening daily, and the court follows up, because the court's responsibility is to protect the vulnerable. So here, there's no one more vulnerable than someone who has taken, their rights have been terminated. Because when their rights get terminated, often we're talking about the right to vote is removed, the right to own firearms is removed. So we're talking about the most core base constitutional rights someone has, they can lose during this process. So the court will protect these individuals from neglect, exploitation, abuse, and financial harm. That's why these reporting requirements are so stringent. I look over every single one that I get before signing, because I have to approve every single report that gets filed. But the core of it is really respecting the dignity and the rights of the individual. And those interests are not always easy to balance. Sometimes family members strongly disagree. Sometimes there's concerns about finances. Individuals and families often bring up issues as to character of someone else who wants to be appointed as the guardian, and emotions run very high, because often in these moments you're dealing with families and it involves grief, guilt, stress, pure exhaustion. Families are going through a lot when these proceedings go on. That's why I do advocate that people have these conversations early and plan for these scenarios before being thrust into the courtroom. So all of those oversights are there for very good reason. I do want to go over a couple of, and I think you gathered this from what we've said thus far, is there's some common misunderstandings. Just because you have a guardianship, you do not lose all of your rights. Very often we're talking about limited guardianships. Oftentimes it comes down to living arrangements and medical care. Those are often the most important things in the moment. There's also what's called emergency guardianships. So an emergency guardianship means I need to be appointed before these reports come back, before the report of the doctor, before the report of the psychologist, and before the report of the social worker. So those are extreme scenarios, and often they're applied for actually incorrectly. So sometimes hospitals want to limit their liability, and that's completely understandable. But sometimes there is no immediate harm. An emergency guardianship is supposed to be an extreme scenario where if you're not appointed right now, physical bodily harm or financial waste is going to occur that no one can come back from. And if you meet that standard, you can be appointed as an emergency guardian. However, That does not negate the rest of the process. You still have to go through a typical guardian process. So at our very next hearing, we will have appointed a team, so a guardian, that's the 3 interdisciplinary team, to evaluate, come back with a report. So just because you get appointed to an emergency guardianship, that does not take away all those safeguards. You're just given those powers early, but there is still going to be that intense evaluation as to whether this person needs to have their rights terminated. I hope this is giving you some indication of what's happening in the courtroom and how this works. It's really about protecting people during all seasons of their life and really making sure that people have dignity and respect when they've reached a point, either through dementia, injury, incapacity, where they no longer have the ability to fend for themselves. If there's any questions, I think I got the wave that my time's coming to an end, but I'm happy to start.
I'm Gary Ashby. I'm the state president for AARP, and I often talk about frauds and scams across the state. There's a hesitancy of older adults who have been tricked out of their money by criminals. There's a fear of a lot of people that if they report what happened to them, that they will lose their financial independence. Could you address that?
Yes, just because someone makes a bad decision or makes bad decisions does not mean they lose their autonomy. It comes down to individuals. I've made poor decisions myself in the past. That does not mean that I lose my rights as an individual. So absolutely, I encourage anybody, anyone can fall victim to fraud or scams. Certainly they try to prey on the elderly, oftentimes because of technological deficiencies. That does not mean, just because you're not great with working a computer, does not mean you will be terminated of your rights. Absolutely not the case. So yes, I have seen those concerns and things have come up of that nature. I do want to point out that people often get very scared of, they're in a vulnerable state, they may not understand the full proceedings, and then they hear someone's going to be over their finances. At that point, I have seen people panic. The court is always going to make the best decision that it deems necessary, if that's appointing a fiduciary or conservator. But I want to point out that all guardians and all conservators have to post a bond. So a bond will be made and an oath will be taken by a guardian and conservator. That is there in case there is any malfeasance. When these reports come and through observation of what's happening, the state will come after that bad actor for those monies. So there are safeguards in place to prevent guardians and conservators from malfeasance. Any other questions? Yes, sir.
What kind of time frame are we looking at here? Some are very complicated, they'll take time, but what if a family is all in agreement and the assets are nil, and the only money we're talking about is a Social Security check?
Yes.
And the person has not only dementia, but also a psychotic issue.
Yes, sir. Most often, best case scenario, we're talking about a 1-month process. But I would always say that it's probably about 2 months, because there is the logistics of just getting in for those appointments. Doctors' offices don't always have those openings. Best case scenario, absolutely, it can happen in a 1-month process, have one hearing, and if all the reports are in, if family's in agreement, there's not a big hearing to be had about who will be appointed, then it can be a very quick, streamlined process. And that's best case scenario, but I would always estimate about 2 months because of the logistics of making those appointments.
Thank you.
Absolutely. Thank you, everybody. It's a joy to be here today, and I appreciate it.